Hello friends, Namaskaram, Vadakkam. Today I'm going to discuss an important topic concerning prevention of corruption. The topic is too much hot. We are having a case under Prevention of Corruption Act, but in absence of ideology, how to contest, we are not able to fight the same. And some of us tried their best to leave the battleground. It is better to be convicted than to fight. It is your mythology. But I am the great follower of British mythology. Fight till your last breath. They say do the proper research. They say do the proper strategy so that you could ensure you're winning in a false criminal case. The mythology is that every accused shall be deemed to be innocent unless proven guilty. And that's why on said mythology I'm going to convey that you are having rights and protocols under the law. In absence of knowledge, you are not able to contest your case, and that's why you say it is better to leave than to fight. But I'm going to recall you the legal provisions so that you could update yourself and could say, I'm ready to fight. And previously, when we used to say to God, whenever trouble comes, oh God, not me, but this time, after hearing this lecture, definitely you will say, try me. Because you are the only person who is going to make history, who is going to make example for those who are falsely implicated in a case under Prevention of Corruption. And I am having multiple citations for you, but the key point is that by having multiple citations, even at your hand further, you could not secure the acquittal. If you want to secure the acquittal, you must understand the basis. You must understand the norms. You must understand the concepts. You must understand the application of the provisions so that we could ensure the proper winning. Consider the same. I am sharing the important judgment as reference for all of you, that is State of Maharashtra versus Sayyid Hussain. Judgment is dated 1st of July 2025. It is pronounced by Honorable Bombay High Court. In the said case, the accused had been acquitted and ultimately state had filed an appeal before Honorable High Court. The appeal had been rejected by the Honorable High Court, and while rejecting the appeal, the Honorable Court had made certain observations. So ultimately, we have to discuss the success story of the accused while having the proper acquittal from the trial court, so that whenever we are having the same problem, we could contest our case in the same way as contested by accused in that case. The case is quite simple, and I think that it resembles to our story. In that case, the concerned complainant approached the accused, and ultimately he requested the accused to lodge a complaint against Mr. Gulab Khan. And you have to specify in your notebook that accused is a police official at that time. But he failed to take any action, and ultimately to register the FIR he demanded rupees 1000. And it is also decided that the money will be given in two parts, 500 and 500. And finally the matter is reported to Anti-Corruption Bureau, and they proceeded to do the verification, and ultimately the accused was caught red-handed with the bribe amount. Finally the accused was charge sheeted, but he was acquitted by the concerned trial court. The primary attack of the accused at that time was that the story of complainant is highly mismatched. Even there is lot of inconsistency, there is no corroboration, and apart from that, he narrated a different story in the court of law as narrated earlier in the report and verification reports. As we know that the basis of prosecution and conviction under criminal law is the consistency and the corroboration. If the story is inconsistent, story is probable, there is mere surmises and conjecture. And apart from that, the story is totally out of syllabus. In that scenario, the prosecution of the accused under Prevention of Corruption Act is bad in law. As we know that to prosecute a person under Prevention of Corruption Act, specifically a trap case, The concerned prosecution is duty bound to prove the demand, but demand is not a mere demand. Demand means a voluntarily demand by the accused. In absence of specific demand by the accused, the prosecution vitiates and ultimately goes away. I want to clarify you that we are having multiple judgment, even of Honorable Supreme Court, on that issue, in which it is specified that to prosecute a person under Prevention of Corruption Act, it is sine qua non that demand is to be proved. Mere recovery, mere acceptance would not help the prosecution to be succeeded. And apart from that, in judgment of Neeraj Datta versus State of NCT, Honorable Supreme Court specified that for Section 7 of PC Act, there must be an offer by the complainant and voluntarily acceptance by the accused. If the acceptance of that offer is not voluntarily, and apart from that, there are inconsistency in the story of prosecution, in the report, and in the court. In that scenario, the concerned accused would get the benefit. Because demand can be proved by direct evidence, by circumstantial evidence, but to sustain the demand beyond reasonable doubt, the prosecution is bound to place on record consistent and corroborating evidences. If they are not on the record, they cannot secure a prosecution, even a conviction against the accused. To be noted that in the present case at hand, in the report, he is having a different story. 1000 is demanded towards medical certificate. While in the court proceeding, he submitted that he has given 100 rupees on same day and remaining later on. And apart from that, there is inconsistency in the statement of shadow witness on that point. On the point of mismatch, different views are on record. Which view is correct? The prosecution totally failed to answer and explain. If there is inconsistency in your case, for example, the concerned complainant had specified a story in the report. In the verification, we are having a different story. In the transcription, we are having a different story. And apart from that, the witnesses are giving a different story. Even in the statement to police as per section 180 of BNSS. And sometimes the statement of complainant is recorded as per section 183 of BNSS. In that scenario, we could have the benefit. Because remember that in a trap case, even though there is a presumption as per section 20 of PC Act, but despite of that, the prosecution is bound to place on record the basic element by the virtue of which it could say that the offence is proved. Until and unless such elements are on record, it could not be said that the prosecution is genuine. So in the present case at hand, the concerned complainant is self-inconsistent, and apart from that, the theory of the concerned complainant is not going to be corroborated by the shadow witness, and apart from that, the shadow witness had set up its own story. So on the ground of inconsistency, the prosecution failed, and apart from that, the concerned shadow witness submitted that when she raised inquiry from the complainant whether she arranged the amount or not to be given to the concerned accused, she submitted to her to be with the additional amount at PS of rupees 250. What was that additional amount? Not explained by the complainant, even by the shadow witness, and even by the concerned IO. A fatal point for the concerned prosecution. And apart from that, in absence of corroboration, due to the presence of constant inconsistency, even on the point of acceptance, demand, and recovery, the concerned prosecution failed, as observed by trial court. And when the matter was heard by the Honorable High Court, the same scenario occurred. And court pointed out, if the concerned prosecution totally failed to submit the consistent and corroborating evidences in that scenario, they could not bring the accused at guilt. So the present case is a glaring example for all of us. Because in the present case, we are having 5 important points of law to be considered. Number 1, it is the prosecution who has to prove the case beyond reasonable doubt. In case the prosecution totally failed to prove the case beyond reasonable doubt, the prosecution fails. The prosecution cannot take the benefit of its own wrong. Number 2, weak defense, no defense cannot be a ground for conviction. But apart from that, if we are contesting a case of section 7 of PCA, we are supposed to raise the theory of probable defense. We have to hit section 20. If you are totally unable to hit section 20, it might be a cause of conviction. Point number 3, for doing the same, we are not supposed to put in our defense beyond reasonable doubt. We have to create the probabilities or possibilities or inconsistency in the case of prosecution, and we may do so by doing the cross-examination. Number 4, we may also do the same by examining ourselves as a competent witness, which is also permissible, and apart from that, we may bring material in support of our defense in defense box so that the court may weigh the evidences and could add value to our defense. And last but not least, whenever we are having a case on board, the case which is totally false as per our opinion, we have to contest the case on point of inconsistency. We have to find out the difference between the report and verification, the difference between the verification and transcript, the transcript when done, who were present. If the witnesses are not present, we would get the additional point. And apart from that, the trap proceeding, the explanation, the recovery of money, apart from that, the chemical test are the sole criteria to determine whether the proceedings are genuine or not. If there is no legal compliances, and apart from that, the proceedings appear to be in anxiety and the proceedings appear to be inconsistent, there is lack of corroboration, definitely we may secure the acquittal. So these are the important points for all of you. Be alert and be safe. See you in the next video. Till then, Jai Hind, Jai Bharat.